Welcome back. The second hour of News Hour begins. We have a lot to discuss tonight with the people in the know. They shoot from the hip. They don't like to miss best brains on television. Tonight with me in studio, I'm introducing them in a bit, but first, let's take a look at the bold newspaper, the headline that we are carrying tonight for you. You can grab your copies of the bold newspaper as soon as they hit the shelf. And of course, it can only be one: blow to Gachagua as judges stay put. Fresh from blows in the National Assembly and the Senate, the courts last week impeached Deputy President, attempt to block 3 judgments set by the DCJ Philomena Mwilu to hear the impeachment cases fell apart, with judges dressing down lawyers for their conduct during the hearing of the application. One of the things that we'll be talking about tonight is exactly that dress down. But that's not the only story we have. Read about IMF's jobs answer to the Gen Z protest. It's also coming up. And away from that, there's a story about an overhaul call on Moi University as it fights to survive. My alma mater, and I guess my guests here are also from Moi University. That story also in the bold newspaper. And finally, a story about the junior starlets pick lessons from World Cup. Now read about the bold newspaper as soon as they hit the shelf, but that is what to expect. Blow to Gachagua as the judges of the High Court stay put. And earlier on, we had asked you on the big question tonight that should the years be increased to 7 as proposed by Nandi Senator Samson Cherargei, or reduced to 4 as now proposed by Kiambu Senator Karongo Wathangwa. And your feedback are as varied as the locations you've been sending them from. I'd like to read a few of them, and I begin now with a response from Nyahururu. No name, but he says the time limit should be decreased by 4. Actually, he's called Alex from Nyahururu. Kennedy says that it's foolishness and awkward decision. We cannot allow, and all of them will be going home. Away from that, the term of the president and other elected leaders should not be extended to 7, but should be reduced to 4. That's Kariuki from Nairobi. The president term limit should be 4 years and not 7. No name. From Siaya, Vit says 4 years is enough. Tony Kipkoech from Eldoret says it should not be increased. John Washira, a citizen, says no adding to 7 years. It's selfish and I totally oppose it. Should be 4 years term. I support Senator Karugo. 7 years is too long. This is Halima from Soyport. All elective term limits should be decreased to 4 years. This is Lekon. And Justus from Nairobi says 4 years is sufficient. Just a few more, because this has attracted a lot of attention. Munene from Rumeroti says 4 years is enough. Bravin from Kangemi says his answer is no, it should actually be decreased. Should be 4 years term. I support Senator Karogo. 7 too long. Once more, Halima. And finally tonight, the current government has failed to help the citizens in the past 5 years, and it has done nothing but to loot. Why should we grant them more terms, or probably they mean more years, when they have not fulfilled their responsibilities? Now, those are some of your comments on the feedback line 22151. And of course, let's now take a look at a little bit of history tonight. Let's take you back to the date, October 23rd. The year is 2015, 9 years to the day today. And the headline then was corruption, Ruto, Raila allies in more trouble. Keriako Tobiko, that is the then DPP, directs further investigations into the individuals before they are cleared. This is our headline in history. It will come up on your screen shortly. And of course, that was not the only story. There was the story of bribery claims, as Waiguru impeachment motion flopped at the National Assembly. So that was your headlines at that particular time, 9 years to the date today. The more things change, the more they remain the same. All right, now welcome back to studio. Let me now introduce my guests for tonight for the conversation on the verdict. The gentlemen are joining me, and let me begin by introducing Alenga Trusted. He is a governance and policy analyst. I don't know if I got his second name right. He'll be telling me, and I prefer to call him Alenga Mzalendo. And of course, there's Joe Halende. He's also a lawyer and political analyst, also joining us tonight. And of course, Maxwell Miawa, a lawyer and a scholar, joining us on Zoom from Naivasha. Gentlemen, thank you so much for joining us tonight. I hope we'll have a good discussion. And I'll begin with Max, because you're far away. Good to see you. And strangely, it looks like, Max, every time we convene a sitting here, it's all about Kindapin Emanyalo, MOBA. So thank you for joining us tonight. Max, open the discussion for us by telling us or painting the picture of what happened in the High Court today.
Good evening, Ken, and all viewers. I hope you can hear me.
Loud and clear.
Now, the first thing is that it was expected from the petitioner's side that the court would recuse itself, in their view, having been illegally composed. But I think the court was not convinced, and the court has come to the conclusion that the Deputy Chief Justice has got the powers to constitute a bench. What drives that hope, or what drove that hope, is the petitioner's view or hope that the High Court has got a role in the impeachment process. And I think it's an erroneous view. Once somebody has been removed from office by way of impeachment, the court has got no role. But I think that will come out very, very clearly as we continue the conversation.
All right. Thank you, Max. Stay with us. Maxwell is from Naivasha, where he is attending another function, but good to have you tonight. Let me bring this conversation to studio and go to Mzalendo Alenga. Paint the picture for the viewer tonight. What exactly transpired in court? Was it expected that the judges will first find a way around this issue of them having jurisdiction and the appointment of the bench by the Deputy Chief Justice? And did you expect that today will end the night without the vacation of the conservatory orders?
Thank you very much, Ken, for this most singular opportunity to be on your show tonight, and also good evening to our viewers. I think first into what happened today in the courts, it was very much expected, and that is what the petitioners wanted with their application of the bench in terms of its composition, first of all, and then the role that the DCJ played in constituting the bench. Ideally, these are issues that counsels that have practiced for years in the courts know very well that they do not hold water. Yep. But every time you litigate in court and you see lawyers bringing preliminary objection, it always points to some fear of the eventuality of the main case. So you'd rather bring some things in the way that buy you time to reorganize yourself and to figure out yourself properly. So clearly, for the applicants who are basically on the side of the impeached deputy president, it was just a matter of trying to put some hurdles in the way. But these are issues that they understand that even the issue they were litigating about the DCJ, they know that that is an administrative function and it can be dispensed by the DCJ anytime, any day, without seeking permission from anyone. She can actually compose a bench suo motu. She can make such decisions.
Without consulting?
Yes.
Because something that came out of it was that, but you people are complaining here, and the Chief Justice has not even raised issues with that composition. So when you talk about on her own motion, she can actually do it without the involvement of her boss, the Chief Justice.
Exactly, because our jurisdiction expanded or brought in the position of Deputy Chief Justice for such administrative issues to be dispensed without having to wait or rely on one person.
Okay.
So clearly these are issues that the lawyers know, but as I told you earlier, in the courts, you will try to buy time as much as you can.
As much as possible. That's what you think. They are buying time. Let me get it to Joe. Joe, your picture painted.
Basically, this is the view that I've held throughout this process, and I've said it somewhere else. Impeachment process is a political process, but grounded in law and in our constitution. The only thing that the courts can do is to ensure and make sure that the due process is followed. So whatever is happening in courts about this impeachment process is basically the substantial issues there is to ensure that there was a fair trial and the due process of the impeachment took place. But the outcome of the impeachment is there and it cannot be changed, and it will remain that the Rigathi Gachagua is the impeached deputy president, and Professor Kindike Kithure is the deputy president elect. Yes.
That is the position. Article 145(7) of the Constitution and Article 149 of the Constitution fulfilled.
Yes.
Fulfilled without a doubt.
Yes.
Then why is it that, Max, why is it that lawyers to the level of Paul Mwite were still trying to enforce this position that we still have a deputy president? Where was this lost in translation, Max?
I think they're justified in their approach, in the sense that, on the one hand, they do believe in the effect of a conservatory order, as you all know, stops the implementation of an impugned decision or a decision that is challenged before the court. So on that basis, they argue that the replacement of the position of the deputy president has been stopped in court. And given that there are conservatory orders giving effect to the Senate and the National Assembly's decision, therefore there is effectively no person sitting in the office of a deputy president. But on the other side, their argument is, of course, there is the argument of the the respondents, the National Assembly, the Senate, the Attorney General. The argument of the other side is that, look, once somebody has been impeached, it effectively means that he has been removed from office, and therefore there is a value in that office. And I think people can argue either way, but I will take the argument of the respondents in this particular case. The reason why I take the argument from the respondents, and the argument is that having been removed from office by way of impeachment, you cannot therefore continue to cling to hold on to that office. Precisely because the High Court has got no role in the impeachment process. All the benefits, all the yields or harvest that the person of Rigathi Gachagua can get from the High Court is this. Two things. One, he may have the High Court ordering that his rights were violated, and therefore he may be compensated for the violations. He may also have the High Court order that there be a repeat of the process for violations of his right to a fair hearing or the right to be heard. That is not reinstatement. The High Court, or indeed any other court, has got no power to reinstate somebody into office once that person has been impeached. This is an unpolitical statement. This is the correct legal position and constitutional interpretation.
Mm-hmm. Non-political statement, the correct legal interpretation of that. You agree, Alenga?
No.
Yeah? Not a political statement. That's the legal position.
Yes.
Yes.
I think there's a question I would like to revisit. You posed a question, where was the interpretation of the law in terms of the relevant articles exhaustively addressing the issue of impeachment? and where did the council representing the impeached deputy president seem not to agree with the law, then we would have to revisit, like, let's say, Article 145 of the Constitution, which basically defines what happens, and what it defines the impeachment. And ideally, this is what happens, that the law says that once a vote has been taken in the Senate, like it was taken, and it appears like it is confirmed that 2/3 voted in that direction, then an impeachment has happened. So if you litigate in terms of trying to find conservatory orders to stop the man that has been impeached from vacating office, then I think we have lost the process, because the process has already happened. And I think the reasoning of the law was that there shall be no vacancy that extends at a particular time that maybe creates a gray area of us not understanding what happens next. So the law was very categorical in those instances, and it prescribes where an impeachment starts and how it ends and what takes after once it has ended. So for the council representing the impeached deputy president to seem to litigate that fact, then I think it also offends the doctrine of separation of powers, because, as it were, Senate was dispensing their duty as an independent arm of government.
Okay.
So then do we recognize that that has happened? Because when you move into litigating a matter, it means you have recognized that that matter has been seized off. It has happened, actually. Okay. So then when you come to court and still say, I am representing the deputy president, then there's a clash of philosophical arguments there.
Joe?
Yes.
Same thing.
To just add on what Daktari has said, the scholar has said, and my learned colleague, that the other remedy that the impeached deputy president can seek from the court is to see that some of the issues that he's accused of, if they cannot be substantiated, so that he cannot be further prosecuted on those grounds. Those are among the options that he has.
Okay.
But on the other side, this is a pure political process.
Okay.
Even you see the wording of the Constitution, after the impeached and removed deputy president has been removed from office, the deputy president-elect is not just nominated in the parliament, but he's basically voted for
in parliament.
In parliament.
Okay.
So it's more of a political process, but grounded in law. And once the political process has been done in terms of impeaching a state officer or a public officer, holding him accountable, then it means the only thing that the courts remains to ensure is that the due process was followed, and the rights that Rigathi Gachagua as a person under the Bills of Rights has were safeguarded and not interfered.
Then my question then is, this matter has been settled, and I want each of you to weigh in on this. This matter has been settled, that the impeachment has happened, and Dr. Maxwell says that there's no way it can be reversed. Joe agrees also that there's no way the courts will interfere in the impeachment process because they have no role. They look at the process. Then where is the public interest in this tonight? Because from where I sit, I'm looking at a country without a substantive deputy president tonight. We have an impeached deputy president and an nominated deputy president and approved by the National Assembly under Article 149, and of course waiting to be sworn in. But where is the public interest in this matter? Why should we, as Kenyans, ordinary wananchi, be paying attention to what's happening? Is it for academic reasons? Is it for jurisprudence? Max, why should we pay attention on this tonight?
This is quite a critical question of constitutional governance in this country. The issue of impeachment of the deputy president ranks in par with the impeachment of the president. It ranks in par with the removal from office of the Chief Justice or even the Speaker of the National Assembly or the Senate. These are critical anchors of our governance in this country, at least institutionally speaking. On the other hand, these are also serious political questions, by the way. These are very, very serious political questions. They touch on critical alliances that one needs to cultivate when they're joining into politics. There is also the public interest involved in this particular matter. In fact, if one was to go to the level of the Supreme Court, they would be called matters of general public importance. And matters of general public importance are far and above matters of general public interest. These are perhaps some of the reasons why the citizenry need to participate. And I think the High Court should get it right. The High Court ought to get it right. And some of the questions the High Court will be answering is, does the judiciary have a role in the impeachment process? One. Mm-hmm. Two, what are the possible remedies that the court or the High Court can grant once somebody has ceased to hold office? Because if you look at Article 145(7), once the Senate process is incomplete, and remember the Senate process was complete and there was no challenge up to the time the new deputy president was being appointed. So once somebody has been removed from office, do the court still have the power, the remit to return that person into office? This goes to the very question of remedies. And it goes to the question of the jurisprudence that the High Court is going to set. I want to say here categorically that the High Court needs to set groundbreaking jurisprudence so that into the future, when it comes to removal of the president, the deputy president, the Speaker of the National Assembly, or even the removal of a judge, what should be the role of the judiciary? Because if the Constitution ousts the intervention of the judiciary in the removal of a state or a public officer from the office, why would one still run to that branch of the government? Of course, we do know that if one was to read the petition of Rigathi Gachagua very carefully, one of the complaints he raises is that he was not given an opportunity to be heard. Now, not having been given an opportunity to be heard sits at a different wavelength from removal from office. So that goes to the question of process. It doesn't go to the question of outcome. The court can only order a repeat of the process, or the court can order a compensation for the violations of it. That's how I look at it. And I think the reason why this question is so significant, so profoundly significant for the people of Kenya, is that the High Court needs to get it right, at least going into the future.
I saw a petition by the people of Nyeri, if I am not wrong. They were also seeking to be admitted as part of this case, and they were saying the rights of people of Nyeri will be prejudiced by the removal of the deputy president. Is this just an extension of the Murima narrative? I don't know, Alenga, what do you think? Was just an extension? Because I'm looking at the sum total of public interest in this matter and why we need to settle this really fast.
I think for me, I look at it as part of the pile of the obstacles that the lawyers have to put in the way in order to stop or to prevent the real decision of the court to happen. You know, just seeking some period of time before you can actually get the last nail on the coffin that it's over. So I think being that of a litigious is not really of any advantage to the process as it were.
You don't think it was important for people of Nyeri, if I'm not wrong, if I'm wrong you correct me, but I had that application that
indeed.
Yes.
Indeed.
They'll be prejudiced and they needed to be enjoined in this suit.
So I think law is practiced within a society.
Yes.
So what is the quantity of measure to determine that this petition comes from the people of Nyeri? Because the people of Nyeri are not 1, 2, 3 people that can be able to sit down and draft. how did they collect all these views? What was the process?
There was public participation,
how did they generate?
Go to court.
How did they generate this petition as the people of Nyeri?
Yeah.
And how did they depon this petition as the people of Nyeri? So those are the questions that the court should be able to address. But more importantly is what Dr. Ari has looked at, and he said the High Court should be very careful because they are defining the jurisprudence around how we handle future impeachments, and them being able to determine the place of court in all this is what is really important for us. And as far as I'm concerned, and from where I sit, I see that the court must exercise the doctrine of restraint and leave the process to be done by the process to be handled as it had been handled before by the Parliament of Kenya and the Senate. And then now the court can revisit the process, because even the applicant who is in court is not contending their impeachment. He's contending the process through which they were removed from office. Okay. So can the court let the matter rest if the matter of removal from office has no contention, as it were, by now? Yeah. Then why are we holding the second, the next person in line to get into that office?
And more interesting is that tomorrow they're not even dealing with that matter of vacating the conservatory orders. So this might drag longer. I have about 3 minutes, and I need Joe to come in on this. The public interest in this, but as an advocate, that reprimand from the bench, that when the petitioners or the applicants got order after order after order in their favor, they never raised any question. And now, remember they're the beneficiaries of the conservatory order as it stands. And now when this other side, the respondents, get one, now everybody's happy now. And they were reprimanded. In fact, the court used a conservatory word to explain their action. But why was that necessary also? Is it part of jurisprudence?
To answer your first question in terms of the public interest, the person in question here is the impeached deputy president, whom is supposed to be a symbol of national unity, and is somebody who was voted in and put in place by the constitution through a vote by the people. So, of course, it makes this a weighty matter for the people of this country, and it makes it to have, it makes it to be a public interest matter. Then, even when the judges today were reading the ruling, and one of the issues that Dr. Freda Mugambi highlighted are those issues where from the side of Gachagua, they raised issues, and even they went ahead and cast aspersion to the bench and made wild allegations about them getting a fair trial from the bench. So those are among the issues that, to me, I can sum them up as technicality. Because how do you certify a matter as urgent? Then when your matter is placed before the court and want to be dealt with in terms of the urgency that you went to court,
and
then
you said no. The other side now.
Then you said no. You know, when you're talking about Article 50 of our Constitution about fair trial, it talks about, in sub-article E, it talks about untimely dealing with the matter in reasonable time. So it means that when you're talking about fair trial in Senate, it also means that you need fair trial in court so that the matter can be handled in reasonable time.
Okay. Very interesting, gentlemen. When we come back, we will deal with the issue of the hearings tomorrow. They will spend the whole morning tomorrow to